Welcome to Nebraska Arts Council's Winding Down series. This is the second session, Legal and Financial Steps. Our first session was a few weeks ago, discussions and decisions. So if you didn't get a chance to attend that webinar, the recording is available on our website. And this recording will also be available at a later time. Just a couple of notes. You should have received earlier this week a PDF that includes the PowerPoint for today, as well as a list of resources that may be helpful to you if you are investigating the process of maybe closing down or merging or going dormant. Also included in that email was a note on privacy and anonymity. This recording will be available on our website, so if you prefer to remain largely anonymous, you can follow those directions to mute your video entirely or change your name. In addition, after the presentation, we'll have question and answers, and if you do have questions, but you feel like you don't necessarily want to share those publicly with the group or the webinar, feel free to direct message our questions person. So with that, I want to go ahead and start sharing my screen and introduce our presenters. So our first presenter is, well, I should say, they've discussed the order and arrangement. So so I'm just going to introduce them alphabetically. So I'll just give you their name to start, and then I'll share the screen so you can see. So Krystal Siebrandt with HBE LLC, and then Stephanie Mattoon with Baird Home. So let me go ahead and share my screen. Okay. So just to give a little bit more lengthy introduction, Krystal Siebrandt is a partner with HBE CPAs and Consultants, and is, in addition to being a CPA, is a certified fraud examiner and a chartered global management accountant. Krystal leads HBE's nonprofit industry specialty team, as well as the firm's outsourced accounting and CFO services division. Krystal is known for her expertise in serving nonprofit clients. She's dedicated to helping clients in this industry succeed. She strongly believes in the important work that nonprofits do to support and improve their communities. Stephanie Mattoon is a partner with Baird Home Attorneys at Law. She represents nonprofits and for-profits at all stages of their life cycle with respect to corporate formation, mergers, acquisitions, and corporate governance matters. Stephanie has extensive experience representing private foundations in compliance matters and assisting public charities with federal tax law and 501c3 compliance. And both Stephanie and Krystal are active community members and have served on both nonprofit and academic boards of directors in the past. And so I will pass it off to Krystal and Stephanie then. Oh, and actually, one more thing that I just want to mention too. So lots of expertise in this room, but just want to make sure that participants understand that the information that's provided doesn't necessarily constitute like official legal advice. So if you do have questions and things that are related to your specific scenario, make sure to reach out to your financial or legal advisor. Okay, and now with that, I pass it off to you.
Okay, and I think you can probably go to the next slide, Stephanie. So quick overview of what Krystal and I are going to talk about. Basically 3 different scenarios that your organization could be facing given current situation. One, you could be considering merging with another organization. 2, could be considering just ceasing operations and going dormant. And 3, you might be considering voluntarily officially ceasing to exist or dissolving. So with respect to each one of these scenarios, I'm going to go through the basic legal steps that you would need to follow if you want to go that route. And Krystal is going to be talking about financial and tax issues. We're going to do this at a very high level because we are kind of short on time, and we want to leave a lot of room at the end for questions. So if we skip over some gaps, please do submit questions or raise your hand virtually at the end of the presentation when we really do want to get into a discussion of your questions. So with that, Stephanie, I think you can move forward to the next slide. So quick, just to make sure that everybody understands what we're talking about before we get into the specific legal and tax and financial issues. What exactly is a merger? So a merger is it's a statutory transaction that if you're a Nebraska organization, you would follow it under Nebraska state statutory law. If you're an organization formed in another state, you would need to look at that state's law. But it provides that one organization is going to essentially be absorbed by a second organization. That first organization, which is referred to on the slide here as merge org, it will cease to exist. And that happens as a matter of law, by operation of law under the statute. And one organization becomes the survivor. So you can see here in the large font, we've illustrated which organization at the end of that transaction still exists. The nice thing about a merger transaction is that all of those assets of the merge org are automatically transferred to the survivor. So it's a relatively simple, efficient transaction. You don't have to identify each specific asset that the merging organization owns and affirmatively transfer that. All of the assets in one fell swoop are just going to automatically be owned by that surviving entity. And any gifts that are, remaining in wills that are intended to go to that merging organization that no longer exists would automatically inure to the surviving entity. One of the downsides of this transaction is that also, along with those assets, all of the liabilities that merging organization might have, whether they know about them or not, are going to automatically be assumed by the surviving entity. And that the separate existence of that merging organization is going to cease to exist. So if we go to the next slide here, I've got, these are the basic steps. There's a lot more detail to it and nuance, but the basic steps that need to be followed are all outlined in a Nebraska statute, and I've included the reference here for you if you want to look it up. But the main document that you would be preparing, or if you have an attorney, your attorney would be preparing for you, is called a plan of merger. And the Nebraska statute and the statute of any state that you might be organized in sets out specific requirements that have to be in that plan of merger. The basic terms of the merger, and then any changes that are going to be made to your governing documents would be in the plan of merger. So often changes, you would want to change the bylaws of the surviving entity, perhaps to change the general size of the board or the composition of the board, given that probably some of the leadership of that merging organization wants to be involved in the surviving entity. Once you have that plan of merger prepared, you would need to get official approval from the board of directors of each one of the organizations. So the surviving entity and the merging entity. If your organizations have members, and most nonprofits do not have members, member is defined under the Nebraska statute as someone that has the right to vote for the board of directors. So there's a lot of nonprofits out there that have members. They use the word member to refer to folks who maybe get their newsletter or pay dues, but they don't actually come to a meeting every year and cast a vote for the board of directors. So those folks are not considered members under the Nebraska statute. Once you get the approval of the plan of merger, one of the nice things about the merger is that you do not have to seek approval from the Nebraska Attorney General. So you don't have to let them know ahead of time that you're going through a merger. You'll see when we talk about dissolution that it's different for a dissolution. It's also different if you do an acquisition of assets instead of a merger. But if each one of your organizations is a 501c3 and therefore considered a public benefit corporation under Nebraska law, you don't have to get the Attorney General involved. The next step is you would file a document with the Nebraska Secretary of State called Articles of Merger, and that's the actual official document that is going to effectuate the merger transaction. Finally, once you've done that, you will publish notice in the newspaper telling the world that your two organizations have merged and the transaction is complete. And with that, I'll pass it over to Krystal to talk through all of the financial and tax issues.
Thanks, Stephanie. I'm going to take just a step back and note that when you are working through the process of determining whether you will merge, finance it plays a key role. And just like you heard in the last session, where there are a lot of different considerations to think about in determining what your next steps are, the same come into play when you think about a merger. You know, you should be surveying stakeholders and you should be looking at impact, but also you want to do a thorough financial statement review or financial information review of both entities to make sure this is a good fit. Then once you do decide to move forward, there are a couple of things to consider financially. And I'm not going to spend a lot of time talking about tax issues because most of the tax issues would be similar to a dissolution that we'll talk about here in a little bit, as far as the organization that ceases to exist. The organization that continues will continue to file their taxes and other reporting requirements as is. On the financial reporting side of things, if you prepare GAAP financials or generally accepted accounting principles financials, it's important to know that mergers can be looked at in two different ways. An acquisition is basically when one organization acquires another. So the one that is acquired ceases to exist and the acquirer continues. The other is what the GAAP definitions of a merger would be when two or more organizations decide to come together and form a new entity. And so then the existing entities cease to or go away or dissolve, and you have a brand new entity. And so the way you handle those, I'm not going to spend a lot of time going into the details, but I just kind of wanted to highlight that the way you handle those as far as financial reporting is a little bit different depending on which type of merger you have. So just be aware of that from a financial reporting perspective.
Okay, so the next route that you could be considering is, you know, what I think it may just want to give yourself a bit more time. You know, you may think, well, we really can't afford to continue operations, but we don't want to completely shut down. You know, we went through all the trouble of getting our 501c3 status, you know, whenever that occurred. Maybe we just kind of want to wait a little bit and just go temporarily dormant and see what happens. So what does going dormant mean? Well, there's not like a statutory procedure. So I'll probably pass this to Krystal fairly quickly under Nebraska law for what it means to go dormant. It just means you're not going to be operating anymore, but you would continue as a legal entity. So any requirements that apply to you because you are a legal entity will continue to apply. You need to still follow any corporate formalities, any reporting requirements. So Stephanie, if you want to go to the next slide, I'll quickly run through just a few legal issues. Again, not a procedure you need to follow, but some things you should just be thinking about. The number one is if you want to actually stay a Nebraska legal entity that's active, you do need to continue filing that biannual report that you file every 2 years with the Secretary of State. So that's a minimal, you know, very short document you file telling them who your board and officers are, that you do continue to exist. You might want to shrink the board if you're not actually continuing operations, but under Nebraska law, you can't shrink it below 3 folks. So you got to have a minimum of 3 board members. You also need to make sure you're still complying with your bylaws. So if your bylaws say you have a board of, you know, between 10 and 15, but you're going to go dormant and you don't really need to continue having that many folks on your board, you might want to amend, well, you would need to amend your bylaws to make sure that you're still complying. Same thing for meetings. You know, if your bylaws say you're going to have quarterly board meetings, you probably don't need to keep doing that if you're going to be dormant for a while. So you might want to consider making some amendments to that. Think about any contracts that you have ongoing that you might need to terminate. Look at those provisions. Probably if you have any employees, you need to be thinking about dealing with termination of employees, communicating, notifying donors and volunteers and vendors. And then finally, if you are going to go ahead and transfer assets, if it's substantially all of your assets, which unfortunately is not specifically defined under Nebraska law, then there is an entire section of the Nebraska Nonprofit Corporation Act you would need to comply with. And unfortunately, that would require notice to the Attorney General. So if you're basically going to keep owning, assets and just go dormant, you don't need to worry about that. But if you're going to be transferring those assets to another nonprofit or selling them, you would need to give notice to the Attorney General. With that, I will pass it over to Krystal.
From a financial perspective, it's important to know that going dormant doesn't mean you get to sit idle and do nothing from a financial perspective. All of your same record keeping requirements continue. So you would continue to need to file your annual Form 990 if that's applicable to you, which is the annual tax return or information return you file with the IRS. You would also need to continue completing any payroll tax returns or sales tax returns if those have been applicable to you in the past. And even if you're filing them with zeros, it's important, one, to meet those filing requirement due dates, and two, to keep those numbers or keep your status with the state active, so that if you do, or when you do decide to ramp up your operations again, you won't have to go through the process of resetting all of those things back up. So continue to file, but you may be filing zeros or less information on those returns. One other important thing to keep in mind on that front is that you may be eligible to file less frequently or a shorter form. And so when it comes to the 990, if you've always filed the full Form 990 form, you may be eligible for either the EZ or the 990N postcard. And then on payroll and sales tax returns, they have frequencies of filing anywhere from monthly all the way up to annual. So you could look at whether the activity that you have would warrant the ability to less frequently file those. One of the most important things, I think, when thinking about going dormant is that laying dormant year after year after year could actually jeopardize your exempt status. And so I'm speaking about this because on the 990, if you've ever looked at the Schedule A, there's a test of your exempt status, and it's measured in a 5-year increment. And it says, how much public support did we have over the 5 years? And if you had 33 1/3% or less than 33 1/3% public support, your exempt status is in jeopardy of being revoked. So moral of the story, I would say that this is a short-term solution. And when I say short-term, I would think in terms of, is this going to last longer than 5 years type time frame when you're thinking about whether going dormant is the right solution, or should we just dissolve, which we'll talk about here shortly.
Okay, so what does it mean to dissolve, and how is that specifically different from the merger? Organizations that I see dissolve sometimes have considered doing a merger, and there's just been no obvious organization for them to merge with. So what happens? Well, the organization gets rid of all of its assets, it liquidates, transfers those to one or more recipients, perhaps in a sale. Usually it's a gift to other 501c3 organizations, but if you own like a building or something like that, it probably would be a sale to a third party. You do need to identify specific assets. So unlike a merger, it's not like all of your assets are automatically going to go to any specific recipients. You have to identify the organizations that it makes most sense for those assets to go to. Fortunately, they would not assume any liabilities of yours unless those are expressly indicated. And then you go through a specific step of filing a document with the state to dissolve the organization so it ceases to exist at that point. This does not happen by automatically by operation of law like it does with a merger. There's a little more paperwork and a little bit more work to be done. So going to the next slide, we'll go through the general kind of steps that you need to go through to complete a voluntary dissolution. Again, we have the statutory site here for you. And I just wanted to note that what we're talking about here is, again, a voluntary dissolution. So if you look up the Nebraska statute, you'll see there's also references in there to a judicial dissolution, which is an involuntary dissolution that your organization doesn't ever want to find itself in. But there's also reference to administrative dissolution, which is another form of involuntary dissolution, which occurs if you stop filing your biannual report with the Nebraska Secretary of State. We generally don't advise going down that route, but that is what would happen if you stop filing your biannual report. You would be involuntarily dissolved. This is the procedure you follow if the board actually makes an affirmative determination that you want to shut down and dissolve. So the main document that you or your attorney would prepare is called a plan of dissolution. It's going to set out again, a number of mandatory provisions that are in the Nebraska statute. The main thing that it's going to do is identify what happens to our assets. So what assets do we currently hold and where are they going to go? That can be more complicated for you if you hold any restricted assets or real estate, then that plan can be a little bit more complicated. The plan needs to be, again, approved by the board, just like a plan of merger would. And if you do have members, it needs to be approved by the members. One difference here between the merger and the dissolution is you do need to give notice to the Attorney General before you can dissolve. So the statute says you need to give at least 20 days notice. Usually the response of the Attorney General is, okay, no objection, or they might not respond at all, which means you can move forward with the dissolution. Sometimes they respond and they have questions or they need more information. Then you would file the Articles of Dissolution. That's the document with the Secretary of State, which makes you officially dissolved. The organization still exists for the purpose of just completing the wind up and the liquidation, so you can still be transferring assets after that point. You would publish notice of the dissolution in a newspaper, and you may, although it's not required, publish notice to unknown creditors and provide written notice to known creditors of the dissolution. The benefit of doing that under the statute is that it can provide you protection from future liability if you follow that process. You then, again, liquidate your assets, transfer them all to the organizations that you had set out in your plan of dissolution that the Nebraska Attorney General reviewed. And then you would provide a final notice to the Nebraska Attorney General telling them, okay, the assets have all been dispersed with, we don't own anything anymore, we are dissolved, and we've completed our plan. And I see there's been some questions come in. I think we'll probably wait and answer those after Krystal's gone through her portion on tax and financial issues.
So some general considerations from a financial perspective on a dissolution. You should keep your accounting records clear through total distribution. And be sure that those accounting records provide an audit trail of the distributions you did make. So if anyone ever questions whether you followed your bylaws in making your distributions, or how the winding down of your organization occurred, there would be the accounting records to support your actions. Also wanted to mention that it's important to plan ahead for dissolution, because if you think about, having a bank account with a certain amount of dollars in it that need to be distributed, you first want to make sure you've paid all your bills. And some of those bills can come in kind of towards the tail end of all this. For instance, if you're working with an attorney or an accountant like myself, some of the things we're doing to help you file with both the state and the IRS are on the back end of the process. And so sometimes you can get or make a prepayment on those, get a estimate of what those fees will be from the attorney or the accountant. And that way, when you're making your distribution, you can be sure that you have enough money left to pay those last few bills. Once all of your distributions are made and all your liabilities are settled, you'll want to make sure you formally close any bank and investment accounts. And finally, one thing that's often hard to think about upon dissolution is who will maintain the custody of the records that you do have. So it's important that all of your accounting records, your previously filed tax returns, if you've had audited financial statements, all of those things are maintained. And so someone has to physically keep custody of those, or you have to scan them and store them electronically in some way. But it's important to think about that ahead of time, and then also be sure you comply with document retention policies and procedures. Like I mentioned earlier, some of your core documents, like your tax returns and your financial statements, need to be kept indefinitely. As far as the IRS dissolution, or the paperwork to make the IRS dissolution official in their eyes, you can do that all through your Form 990. So you would file a final Form 990 on the 15th of the 5th month after your termination date. So that could be sooner than when your 990 is normally due if you end mid-year. So the way you would do that is you would file your 990 as usual, but you'd want to be sure that you marked the final return/termination box on the first page of the return. And then you also want to attach Schedule N. And Schedule N is where you would document how you distributed your assets and to what organizations those assets went to. And then finally, Stephanie mentioned the articles of dissolution that you file with the state. A copy of those needs to be attached to your final Form 990. If your organization isn't required to file a Form 990, for instance, if you're a religious organization or church, you can write a letter notifying the IRS by mail that you've terminated, and include your articles of dissolution in that letter or with that letter. It's also important to consider your state requirements of notification. So for instance, if you're required to complete a charitable registration for solicitations in any state, you would also need to make them aware of your dissolution. Nebraska does not have a separate process for that, but other states often do.
Okay, and then finally, before we take questions, I just kind of wanted to remind you, if you are on the board of directors that's considering these various alternatives and moving forward, that throughout the time that you're shutting down, dissolving, merging, the board and the officers continue to owe fiduciary duties to the organization and to carry out the organization's mission. So those don't stop when you cease operating your primary programs, they do continue. So make sure that you're following general best practices for exercising your fiduciary duties. Make sure you're creating written records, minutes of board meetings, board resolutions approving these various documents. Make sure you're reviewing the documents, you know what they say, you understand them. You're seeking outside advisors if necessary, asking questions, considering alternatives. So considering, hey, rather than shutting down, are there organizations we could consider merging with that would carry on our mission? And just make sure you're stepping back and taking time to understand. So with that, I think we can move forward, Stephanie, with any questions that have come in from the audience.
Yeah, before we seek questions, I really quick want to put in a plug for our next session on March 10th with Chris Hochstetler, who's Executive Director at Sturm Museum, and Amy Schindler, the Director of Archives and Special Collections at UNO's Chris Library. I feel like I might forget that at the end, so I wanted to pop that in there. All right, so I will go ahead and stop sharing now so that we can start taking questions. And I see a couple just in the general chat. So our questions person, I'll leave to those direct messages, but I can go ahead and pose these questions that came in. So is there a way to dissolve correctly after an administrative dissolution?
Yeah, so I can take that one. So yes, when you go to dissolve correctly, one of the things that you need to make sure is that you are currently active. So if you've been administratively dissolved, which again, we don't recommend. And one of the reasons is, as Krystal said, when you notify the IRS that you've dissolved, you want to be able to provide them articles of dissolution showing that you have voluntarily dissolved. But you can reinstate your entity if you've been administratively dissolved by filing some paperwork with the Secretary of State. And you'll be required to do that before they would accept the articles of dissolution to voluntarily dissolve. But that's a relatively simple procedure. It requires some minimal paperwork to get you back active.
And then the next question is, so say that you hold a restricted fund. So the example this participant gives is scholarship money for an arts ed program, but the new group isn't going to pursue arts ed. How would you handle that in a merger?
Yeah, so that's a little bit more difficult. It depends on what the source of the restriction was and what the scope of the restriction is. So sometimes I see organizations that call funds restricted, but they're actually, that restriction was imposed by the board of directors. So it's not really a restricted fund for purposes of Nebraska law. If it is truly a restricted fund under the Nebraska statute that governs this, it's possible that you would need to go to court and get that restriction lifted. So for example, if in a will, a donor said these funds are going to be gifted to this organization, but they have to be used for this purpose, scholarships for arts education, and that scholarship has to be administered by this organization, you would actually have to go to a court and ask them to lift that restriction if you wanted to transfer those funds to another organization, either to use the funds outside the scope of that, or sometimes just to transfer it and have someone else administer those scholarships. But we do this a lot, we actually review the language of the will or the gift instrument or the solicitation campaign that you were using when you raised funds to determine whether there's actually a restriction that requires court approval. And sometimes if it's kind of a fuzzy issue, we will include in our notice to the Attorney General, if it's a dissolution, hey, we have this potential restriction. We don't believe it requires court approval, and then kind of get the Attorney General's opinion on that, whether they agree with us.
And one other thing I might add there too is if the donor is still alive, you could potentially go back to the donor and get their approval of that. So that's kind of best case scenario, is that your donor is still alive and could give that approval.
And Stephanie, would the idea that, I guess if this, so this is Mario, and I apologize, Mario, I can't remember what state you're in, but would that be fairly advisable or fairly common from state to state, do you think? That if it isn't a will or something like that, that it would probably require a little bit more state oversight?
Yes, that's generally a uniform statute that's in place in most states. I can't speak specifically to other states, but yes, that's generally a uniform statute that's in place most places.
Okay. And then I actually had a couple of thoughts or questions too that came up during the presentation. So one thing that I thought would be good to unpack a little bit is, would a plan of merger be good to prepare even if it's not required in a state that I live in? So, you know, if it's Idaho or something and maybe they don't require a plan of merger, would it still be good practice to have that?
So if your organization is going to do a merger, but your state statute doesn't require a plan of merger, I think it's highly unlikely that a state statute wouldn't require, they might not call it a plan of merger, but they're going to require some document that says the basic terms of the merger. So, you know, who are the parties, what happens to the memberships, if there's any memberships when there's a merger, what changes are going to be made to your governing documents. If that's not required, yeah, you want to make sure the two organizations have agreed on all of those kind of fundamental aspects of the merger. And the way the documentation I recommend organizations go through is actually before they prepare the definitive plan of merger, which can get kind of complicated and have a lot to it. I often see them do kind of a more basic term sheet that's non-binding, but just to make sure that everybody's kind of on the same page. So sometimes the two boards are very excited. Like, yes, we definitely want to do this. We want to merge. But then once we start asking them questions like, okay, well, who's going to be the executive director and who's going to be on the board after the merger? You know, they need to kind of take a step back and make sure that they actually have a fundamental agreement on those things before they move forward with the legal documentation. I don't know if that answers your question, Stephanie, but.
Yeah, no, it definitely does. It definitely does. So maybe we can check in with oh, Bob, do you have a question? Do you want to unmute and let us know what your question is?
Yeah, I have two. One's pretty simple. If you only have a merger if you're combining organizations that are incorporated, right?
Correct.
So if one organization is incorporated under the laws of the states with the Secretary of State and the other isn't, that's
so if the other organization just is an unincorporated association.
Yeah. Because you're likely to run into that with art organizations because some are, you know, more organized than others.
Mm-hmm. Yeah, and Krystal, I don't know if you have thoughts on that. So if you are not a nonprofit corporation under Nebraska law, you're unincorporated, then you're not subject to any of these rules that that I've been talking about. You know, you're not subject to the Nebraska Nonprofit Corporation Act. I think it's unlikely then, Krystal, probably that you would have 501c3 status, right? Mm-hmm. So you would.
Right. So there are some rules for really, really small organizations that they can be unincorporated and kind of recognized as tax exempt. But I think most are nonprofit corporations and have filed for the 501c3 status.
Can you get 501c3 and not be incorporated?
You don't get official determination, no, but you can. Like I said, if you're small, I think the threshold's even like $5,000 and less in gross receipts in a year. You can be kind of recognized as tax exempt with, you know, just meeting that threshold. But again, you're not accomplishing too much with that level of activity.
Okay. The second question is that, and this may be true of other community foundations, but the Lincoln Community Foundation oftentimes encourages organizations to become financially connected with them for certain benefits, which then when they dissolve, or the finances all go to the Lincoln Community Foundation. So how does that fit into all of what you've been talking about? Or are you even familiar with that happening?
I'm familiar with, that you can write into your bylaws, and Stephanie probably has more information on this, but a specific organization that your assets would be distributed to.
Okay.
I'm also familiar with like Lincoln Community Foundation and how they hold funds or invest funds for other nonprofits as well. And I suppose that if your mission and your programs fit in with the community foundation, that your dissolution assets could go to them.
And probably if it's a well-run community foundation, which the Lincoln one is, they probably take care of all those details when you assign your money to them.
Yes, I think that would probably be written in your agreement with them.
Okay.
Yeah, did you have anything else to add to Krystal's response, Stephanie?
Well, I was just going to say, so if a nonprofit corporation, when you apply for 501c3 status, you have to show the IRS that you have a dissolution clause in your articles of incorporation. So all nonprofit corporations that are 501c3s have a clause in their articles that says what's going to happen to your assets upon dissolution. Usually that clause is pretty general and just says, upon dissolution, our assets are going to go to another 501c3. Sometimes it says another 501c3 that carries out our same mission or a similar mission. But as Krystal said, sometimes it names a specific organization. So upon dissolution, our assets are going to go to, the University of Nebraska Foundation, or it will name a specific recipient organization. So one of the many things that you need to do as you prepare to draft that plan of dissolution is look at your articles and make sure that the recipient organization or multiple recipient organizations that you're naming complies with your dissolution clause in your articles.
So I think,
yeah, one thing, I'm just looking at our articles of incorporation. We just went through a big bylaw thing, so I'm got all these copies and everything. And we don't have that sort of a clause. We're 56 years old, so maybe when we
probably
started,
time for amending your bylaws then, Bob, I'd say.
well, but
Bob, I hate to interrupt you. I just want to make sure that we give a little bit of time for to check in with our questions person and see if there have been any direct messages. It's 1:45, sure. But maybe we could circle back after we hear some of those questions. Sure. And also, too, I should say, if we're not able to get to your question today or somebody else's question today, definitely reach out to myself and I can connect you with Stephanie and Krystal to, depending on the question, have that question answered, or they could maybe refer you to an attorney or a financial advisor. So let's check in with questions and see what's come in.
Yeah, there are a few. One interesting question is, what are the biggest mistakes that organizations make when merging or dissolving? I guess, have you seen examples of this, of mistakes that have been made and what to avoid?
One mistake that I might point out is that I sometimes see a nonprofit dissolve, distribute all their assets as they should, but then not file that final Form 990 or never mark it final. And so then now the IRS has a process where they'll revoke your exempt status after 3 years of non-filing. But I think I would, point out that that's probably not the best way to wind your organization down with kind of that black mark on your record. It would be better to just go ahead and finalize that final Form 990 as your notification to them and wrap that up in a good manner.
Yeah, I would say one of the mistakes I see most often is kind of a combination of two approaches we've been talking to today, which is an organization goes dormant, either because they mean to or it just kind of happens. And then several years later, they actually want to go through the process of dissolving. So basically, they just kind of wait too long to move forward with that. At that point, a lot of the board of directors have kind of jumped ship. You're dealing with maybe 2 or 3 people that are left paying any attention to this. They can't find documents, they can't find records. They may not even have the minimum number of board members that you have to have under Nebraska law. So when it comes time to give all that information to the Attorney General, they have trouble locating the records. They have trouble complying with the requirements that you have board approval. And so it can just be a lot more painful for those remaining board members who are often, voluntary board members trying to do the right thing and get this cleaned up. But that can actually trigger more questions from the Nebraska Attorney General and make the process more prolonged. So I think if it looks like it's time to shut down, it's probably better to do that sooner than later, so that it's easier for those board members that are trying to go through that process of the paperwork and getting Attorney General approval and all of that.
Well, that's really helpful. Well, here's an interesting, gnarly question. Why is it necessary to give the Attorney General notice before dissolving, and might that trigger some kind of an investigation?
Yeah, so the reason it's required is because the statute says so. And as you know, as nonprofit corporations in Nebraska, the Attorney General is the enforcer of nonprofit laws in Nebraska. So they are the ones that, if there's complaints about a nonprofit organization in Nebraska, they are the ones that would investigate those complaints. So I do have clients sometimes that are nervous about getting the Attorney General involved, that's going to invite the Attorney General to just look further into their organization, and are they going to dig and find things? And the answer is generally no. I mean, usually the Attorney General is very cooperative. If there are missing, I've even had an organization that couldn't find their bylaws and couldn't get 3 board members. And ultimately the Attorney General kind of gave us a pass anyway, even though we didn't technically comply with all of the documents that needed to be provided. I'm not saying that's going to happen, but generally they're very cooperative. And, I think where you actually get into trouble with an potential investigation by the Attorney General is if you haven't given notice. So for example, if you're trying to dissolve and several years after you shut down, but it turns out when you went dormant, you did go ahead and sell off all of your assets. So you sold your building, you went ahead and transferred assets, and you've been sitting as a dormant legal entity, but you don't have assets anymore. When you go to dissolve, it's going to be apparent to the Attorney General that you didn't give them notice back when you should have, when you transferred substantially all of your assets. So they're going to then ask questions about what happened back then, and they're going to probably ask harder questions than they would have if you had gone forward and given notice that you should have at the time. So generally they're not scary, they're very easy to work with, but where they do get upset is when you're not following the requirements that you should have.
Okay, additional question is, do you have any examples that would help us to understand when going dormant is a good idea?
I think it goes back to the decision being something that's short term. So if you feel like there's going to be an opportunity for some grant funding a few years down the road, or you just need some time to kind of recreate the organization or reinvigorate the organization, that might be when going dormant would be advised. But again, it's not a long-term solution because you're not really fulfilling your exempt purpose if you're sitting dormant for a while. Dormancy is really about not having to go through the legal steps and the paperwork of resetting up a new organization. So it's going to be something that you have plans down the road to continue and grow.
One word of caution, because I hear this a lot, just kind of in the nonprofit industry, is, well, maybe we should go dormant but not dissolve so that we can keep our 501c3 status in case someone else wants it. There's sort of this thought that you can just transfer your C3 status to someone else. They could take over your organization. That is not advisable for a number of reasons, but I'm sure as Krystal is probably thinking mostly because your C3 status is based on what you've told, information you've given to the IRS about your mission and your activities. And you can't just kind of transform that into something entirely new with a new board of directors and a new mission without getting the IRS approval for that. So I would caution against that, because I do hear folks talk about that sometimes, that sort of there's like value to having a C3 and maybe we could like sell it off to someone else, which is generally a bad idea.
That's a great point, Stephanie. I think even if you are in the process of recreating per se your organization, it's got to still be in line with that original purpose and mission. And if it's not, probably dissolving the old one and starting a new one is the better approach.
Thank you. There's one more I think this is a really good question about mergers. It says here, if I've been approached by an organization that wants to merge with mine, what kinds of issues at their organization should I be asking about?
That's a very good question.
I think you want to make sure it's a mission and purpose fit. You want to make sure your organization will not be harmed by that acquisition, as far as Stephanie talked about earlier, about really knowing what the liabilities of the other organization are. People-wise, you're going to want to know that it's a good cultural fit. You're going to want to know that your stakeholders are on board with the merger and what that entity could bring to the current organization. It's going to be a big discovery process.
Yeah, I think that's excellent, Krystal. I generally advise clients that they should treat it like they are buying another organization. So go through really the same due diligence process that one of my for-profit clients would be going through if they were going to buy a company. So asking, liabilities from my perspective is huge, but that's going to be not just looking at, well, have they ever been sued, but asking really detailed questions. So for example, I had a nonprofit client that was looking to do a merger. When they started asking more questions about not just current employees, but former employees, it became apparent that there was a real risk of a potential claim by a disgruntled former employee. They opted to do an asset transfer instead of a merger, so that they, would hopefully not assume any of that potential liability. But I think that is one mistake a lot of times nonprofits make as well. This is just a gift. They want to give their organization to us. How lucky are we? But you really do need to treat it more like you're doing due diligence, that you're acquiring this organization. And Krystal makes a really good point. The primary thing is making sure it's a good culture and mission fit, but also understanding the scope of all of the potential liabilities that you're acquiring is huge.
So I don't see any other questions in the general chat. Bob, it looks like somebody did respond to your earlier question. Mario responded to your earlier question. We've just got a few minutes, so if you can squeeze your question, Bob, into just a couple minutes, we might have time to cover it before we bid everyone a good day.
Well, no, I think what I was looking at was answered enough for me to look into. The one thing that, to go back to the last question that Krystal and Stephanie answered, I would think the first thing you want to do is make sure the person that wants to merge with you, they themselves are incorporated.
I think that's a good point. Yeah. Back to your earlier question, Bob.
Because, there are lots of organizations out floating around that, might not be incorporated. They may be quite successful.
Mm-hmm. And you're definitely going to want to see all their organizational documents for sure. All the past tax returns they filed, all that good stuff.
Yeah, just a simple church check with the Secretary of State to see if they even exist.
Yeah,
Right.
absolutely.
And I think, back to the first session too, the, very first slide, I suggested people answer the question of why they want to have these conversations. And I think the reverse is true. If you're approached by someone that wants to merge, it's perfectly valid to ask, why would you, why do they have that in mind? If they have trouble answering that question, then you really want to do your due diligence, I think.
Well, just along those lines, it is possible to, in a sense, merge, although it's not in the sense that we've been discussing today, for a variety of organizations that are incorporated, that have boards, et cetera, to want to merge, say, for the purpose of consolidating staff or getting better staff service or better administrative service, which would be something that would be an agreement between the organizations, but not a corporate merger as such.
Yeah.
I know of at least one instance in Lincoln where one office manages 3 or 4 arts organizations, which are each, I think, separate and independently incorporated.
Yeah,
Right.
right. And that can happen when you have, new organizations too, sometimes haven't been incorporated, don't have their 501c3 status, and can essentially be brought under kind of like a division under an existing incorporated organization. So it actually would be more complicated than doing a statutory merger to combine 2 organizations if one of them is not incorporated. But I think it's certainly possible to have an agreement and kind of transfer their assets and programs over to another organization.
I hate to interrupt, but we're at 1:59, and I just, since I have a minute, I just want to put another plug in for our next session on March 10th, 1 p.m. Central Standard, on Wednesday with Chris Hochstetler and Amy Schindler. And we're going to be really investigating ideas about how to, instead of looking at the financial assets, we're going to look at how you sort of transfer that legacy to possibly another organization in your community. How do you maintain that goodwill? How do you communicate? How do you care for your staff and donors during that difficult process? So want to put a plug in for that, and really want to thank you, Stephanie and Krystal, for being with us today. I feel like you provided so much good information, and it's been really, really helpful. So really want to express my thanks to you for that.
Thanks for having us. It was my pleasure.
Yeah. Thank you.
Thanks. All right, everyone have a wonderful afternoon. It looks like the sun might be coming out here, so we'll see you next time.